Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Severine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law. Hello, we're here for our 12th episode and delighted to still be sponsored by Newcastle Law School. We'll talk more about our sponsor later on. But with this episode, the time has come. It's, I would say, the day of reckoning. We, and I'm using the term we quite loosely because I'm not quite sure why I'm attending this podcast. But anyway, we are discussing a case on the topic of, yes, you heard correctly, good faith. The ultimate topic of contention. The case before us today is UTB LLC and Sheffield United. It's a High Court decision, don't let that put you off, by Mr. Justice Fancourt. And as you'll know by now, we often sacrifice ourselves for our listeners, and there's no better example, I think, than this case, where we've had to drudge through, over 120 pages, background and rambling. Who chose this case anyway? 138 cases, there you go. Maybe I just stopped at 120.
538 paragraphs.
Oh dear, yes, and it felt like that as well. Well, we've limited ourselves here, though, and we have to tell this, I think we have to put this caveat in at the beginning. We've limited ourselves here to the contractual part, in particular good faith bit. I think that's what we're going to be discussing today. And we'll be ignoring all the additional matter of Section 994 of the Companies Act and costs and all that kind of stuff. So, the case, and it can be summarised a little shorter. The case is all about a contract which was aimed at catapulting Sheffield United into the Premier League of English football. Now, I have to be careful here. I know very little about football, so I'm going to stop at that. I think that's what I've gathered from it. The joint venture, that's what it's been called, from which this dispute ultimately arose, was an agreement between Sheffield United Limited and UTB LLC. And Prince Abdullah, a Saudi prince, invested £10 million in UTB, which through another company, another vehicle, owned then 50% of Sheffield United Football Club. Now, a lot happened between entering into the agreement in 2013 and then 2017 and later 2018, including a lot of further investments, but no promotion to the Premier League, at least in that time period. And by 2017, the relationship had deteriorated to the point that the owners of Sheffield United sought to end the relationship and issued a so-called call option notice. Now, a lot of manoeuvring occurred from here, and we'll probably talk about the details later on, but in short, Sheffield issued the call option at the low price of £5 million because they then assumed that UTB would serve a counter notice to buy Sheffield's shares at that price. And why would they want that, you ask? Well, it would have triggered the exercise of the obligatory property call option. That's quite the mouthful, which would have been in Sheffield United's interest. However, before issuing the call option, UTB transferred 80% of its shareholding to another corporate vehicle and therefore avoided the property call option. Sheffield United now stood to lose quite a lot because they were going to have to give up their shares for quite a low price without the benefit they thought they were going to get. Sheffield United argued that UTB had therefore acted unlawfully from 2017 to 2018, contrary to the terms of the investors' agreement, and they didn't act in good faith with them. Sheffield United also argued that other terms should be implied. We'll talk about those a little bit later as well, I think. So let's begin then by asking. The argument was that by the very nature of the agreement, it being a joint venture here, the term to act in good faith should be implied in law, not in fact. And this is a point that one might well be able to take from cases such as Yam Seng, although you could also take the theme that all football cases should have terms implied in good faith. But there we go. Séverine, your thoughts then on should good faith be implied as a matter of law?
Haha, so here is the conundrum. I know nothing about football either, but I do appreciate the financial stake, which now I understand reading the case that actually Sheffield United eventually did get into the Premier League. And I think, I have gone through the 538 paragraphs, so I know that it was valued at something like 195 million, which was, therefore the 5 million that you mentioned, for the shares was a really, really good bargain. So, the financial stake is important here to mention, otherwise there wouldn't have been such a lengthy dispute. So whether it should be implied in law, this is linked to the argument that as a joint venture, it was a relational contract, and the pendulum between Yam Seng as a very strong advocate, legate, as he then was, for having a spectrum of viewing contracts between that, not looking at it purely on a dichotomy basis of fiduciary relations and pure commercial contract where the parties deal at arm's length, that we should have a spectrum of, we should view commercial contract as a spectrum, and therefore the relational contract would allow us to view these and therefore to indeed have an implied obligation of good faith in law. Yes, I am a fervent advocate of this. I think the dichotomy is indeed too simple, as Legate said in Yam Seng. But clearly here, the court, fan court, was not a fan, or is clearly not a fan of good faith, because he seems to have used the last decision of Legate when he was on the bench, Al Nehayan, as going back onto what Legate was saying, that therefore it's just a matter of implication of terms, and therefore we look at the normal rules. I will mention the quote, which I'm sure we have all picked up on. A reasonable reader of the contract would consider that an obligation of good faith was obviously meant, or whether the obligation is necessary to the proper working of the contract. So here we go back to the normal manner of implying a term, and that has nothing to do with good faith. That's fan court's view of it. I disagree with it. I completely agree that the notion of relational contract needs to be explained and tangled. Fan court makes the point that just because it is a relational contract, that's not enough, or that the matters of defining a relational contract, the definition is not sorted. But I agree in principle that there should be a middle ground between fiduciary and normal commercial contract, where we view the parties as dealing at arm's length. I think this is a backward, or this is a dated way of looking at the way business is done contractually in the United Kingdom. So yes, there should be a possibility through the lens of relational contract to imply a term of good faith in law. My position is set.
Well, and let's hear the other side.
Okay, then I'm going to have to try and persuade you, Severine, that you are in error. Okay. Here goes. No, I disagree, Severine. The term implied as a matter of law is, to put it neutrally, an ambitious response for the English common law. It wouldn't be orthodox at all in its approach. So I would agree with Mr. Justice Fancourt completely, actually. And I think this case is more in keeping with the traditions of English common law than the Bates Post Office line of argument, for example, that Fancourt J does criticise rather obliquely, but I think he does. Let me try and persuade you thus. The first point, I think, is to remember that terms implied by law are rather exceptionally done. And this is because English law has a great hesitancy in this regard, because it's the closest I think a judge gets to actually creating terms. So judicial interference, if you like, with the freedom of contract idea is most clearly articulated and argued whether a term implied by law. And it's because of that potentially disruptive impact on the principle of freedom of contract that English common law is very reluctant and hesitant to go that way. So it is much more orthodox and conservative with a small c to say a term that you might simplistically label good faith is possible to be implied as a matter of fact, but you're going to have to articulate that in a great deal, a high level of specificity, as it were. So simply saying good faith, I don't think will cut it for English law. And that's why I suppose I would say that the council in this case went to some efforts to articulate precisely what they meant by that. So that's the first problem. To an English lawyer, traditional old-fashioned bod like me, the label is apt to mislead, and therefore it is dangerous. If you're trying to imply a term, you're going to have to do much more in terms of nailing it down as to what you mean. Because when we talk about a spectrum, for example, at one end, probably an item that most people would have no difficulty agreeing with, that is simply honesty as opposed to dishonesty in a criminal law understanding of that word. I think probably in most contracts, relational or otherwise, that's perhaps not a great struggle for English law to see as an implied term as a matter of fact. But at the other end of that spectrum could be something like commercially unacceptable behaviour. And that we have great difficulty with. An English lawyer would say, well, what the hell does that actually mean? Because if you're implying a term, that means you're imposing something into the contract which is not currently articulated, not currently legible, if you like, to read and to know and understand. So it's potentially quite an aggressive position to take. And therefore, you've got to nail it down with a great deal of precision. And that, I think, is why Fancourt is Honoured Judge Fancourt is trying to say it would be safer. And what he's trying to say is it's more orthodox approach to say, OK, you can have a term implied as a matter of fact, but you're going to have to be able to say that in order to make this contract function, workability, it needs to be there, although it's not been articulated. Or alternatively, it is so obvious that any reasonable reader of the contract, the terms that are written, would say, yes, it is bound to be there. So there's the basic test for implied as a matter of fact, is this concept of workability or obviousness. And that's the way, the mechanism that traditionally English common law would operate on in terms of implying a term. And that's why we use this jargon, implied as a matter of fact. That's entirely acceptable in terms of English law. I have no difficulty with that as a matter of principle. Implying a term that you might simplistically label good faith using that mechanism, but you were going to have to articulate it with a high degree of precision as to what you mean when you use that simple label, good faith. It's not enough. So do you mean an obligation as to transparency, disclosure of certain information, an obligation to be open in some particular way? That's fine, but simply good faith, I have difficulty with that, and so I can see exactly how the judge in this case has difficulty with that.
But wouldn't we be able to say, I mean, we may well say that there's no, even if there was the implied term, that there may not have been in breach of that, and we can look at the fact-specific part, but I think we're still on the principle of whether we should have good faith implied in law. And on that point, wouldn't it be easier to say that this type of contract, a joint venture, requires a certain amount of unspoken, unarticulated input from the parties, like in I'm saying that you just need to be honest, that you need to, or in other cases, as you've just said, the example of you need to disclose something. Shouldn't that be the norm? And then we can say, and because it's implied in law, and then you say, well, unless the parties, of course, don't want that. And then the parties can get rid of that. But generally, a joint venture, I mean, the whole point, it's in the name. It's a joint venture. You need people to be honest. You need people to be open. Whether they breach that here, I think, is another question, because the argument could be that the first issuing of the call option in itself doesn't sound to me to be particularly honest.
Well, then you get into a further problem as to the duration, if I can express it that way, the duration of this supposed obligation. At what point will it end? Because you talk about performance, but that's a point that I think Judge Van Court makes. He's saying, okay, it's a joint venture in that very sort of loose sense, but it's actually also at the back of this is a power struggle between two quite powerful, dominant people, and probably at the end game is only one of them can win. So it's joint venture up to a certain point, but that point comes at which actually they are in contest with one another. So this obligation of good faith, however you end up trying to articulate it with a degree of precision which an English law can hack, it will have a natural end point. And so that's a further point. Had the relationship got to a particular point where any supposed implied obligation as to good faith, as I keep saying with some degree of specificity more than that, has naturally come to an end.
Well, it comes to an end when the contract comes to an end. So I think
Well, no, I don't think that can be right, can it?
Well,
because of the nature of this arrangement, there was a point at which the relationship had broken down effectively on a sort of human level. The date at which the contract ends might be a much later point. I have trouble with this duration idea as well.
Well, so I wanted to reply to you, Maggie, but also to point some of the things that Tim has said, which are important. So I completely agree with you, Maggie, that the problem at the moment, and I think Van Court could have actually developed so much more. I mean, we have 538 paragraphs and only what it seems, very few pages on good faith, and not all yes, he does criticize Bates, but he doesn't go into details. And so effectively on that, it's a little bit disappointing, because what you have said, Maggie, a brilliant description of the conundrum, what I have called elsewhere, the vicious circle. So precisely because at the moment we are, or English law in the way it develops, there is a schism between what seemingly the parties want. So one of the points that Van Court makes is that, well, there is no need in any case, because he's quite reluctant to imply a term here because the contract is very, very detailed. As he points out, they have included good faith, and therefore that is an indication that therefore there was no need to imply a further term, because they had clearly thought about, the instance. But so that's the one thing. So the point that you make, Maggie, that it's not clearly articulated. And I think that's where the issue comes in, the vicious circle, because the courts do not quite know how to deal with, and I think, Tim, you mentioned the unarticulated element. And I think that's the beauty about relational contract. So relational contract, to draw on to Professor Mitchell in Birmingham and lots of other authors, it allows a way to express what the contract doesn't necessarily say. So the relational element is an important conduit to bring in good faith, because it would allow the court the vocabulary allow the courts to articulate what is currently not possible to be articulated, precisely because of the values upon which contract law is written and has used for a long time. So that is where the vicious circle, they don't have the vocabulary, they don't know how to use it because the doctrinal element is not there. And so therefore the courts go back to, well, we can't do it. And so that creates, what I have argued elsewhere, a vicious circle. And so therefore here we go on. So therefore we don't need good faith. So that's the first point, that if you look at construction contract, if you look at employment contract, there is the notion of the mutual trust and cooperation. So what you have said, Maggie, is good faith is actually very often used in the Yanseng, in the Bates, as an excluder of bad faith. So yes, of course, dishonesty is an obvious thing. So don't do anything that would be, as you said, Maggie, commercially unacceptable. These are elements which can be easily understood, but I think
Yes, but can I just chip in at that point? Commercially unacceptable, that I have said is inherently vague and uncertain. If you sort of run with this idea for the moment, how on earth would a court decide what was commercially acceptable or unacceptable? Is this a matter of expert evidence? Because it would not normally be. Expert evidence would normally be things to do with technical matters outside the expertise of a court. So how are you going to prove what is commercially acceptable or not? Because a judge is not really geared up to make that sort of judgment. They're not naturally commercial people.
And yet,
how are they to judge?
And yet they don't have any problems to look at the reasonable expectations. So what is commercially acceptable would be defined.
But it can't be reasonableness, though, can it? It can't be reasonableness, because the basic test of any implied term is reasonableness is necessary but not sufficient. So that's not going to cut it as a test. You can't say to the judge, you, judge, must decide commercially acceptability from a reasonableness angle. That does not fit with the English common law idea of an implied term at all. A judge would say, well, it has to be reasonable, but it needs to be something more than that. What is the something more for commercially acceptable?
That it is according to the expectation based, again, and we go back to what is defined into the contract, but more than that, the unarticulated, what is not said into the contract, that is the standard, and that standard is not the court, when, and I know we imply terms and interpretation are different things, but they are nevertheless linked. And so in relation to interpretation of contract, the courts do not have any problems in looking at the commercial common sense of the parties. That's something more. So I also...
But that's the very low level threshold, isn't it?
Yes, it doesn't...
Commercial common sense just means it's workable. It doesn't mean it's fair or reasonable. Do you see my problem? That this idea of good faith and commercial acceptability is coming so close to this idea of what is reasonable or not, as to come so far away from the English common law perspective of an implied term. Reasonableness is not the test. It's something much more than that. So what is the more?
But the reasonableness angle is what comes from, so as the barrier to an implied term. But the implied term, if it's implied in law, is not related then to the reasonableness. So the reasonableness test is the second stage of the test, as it were. So
yes, but do you see a term implied by law is close to a judge making policy law? What is reasonable from a social background, for example? You know, that the employer-employee obligation of fidelity and good faith, trust and confidence between an employer and employee. That is the closest thing we have to the common law creating a term that is not there. And so can you see judges will be very hesitant to use the mechanism of an implied term as a matter of law, because it is so aggressive, if you like, in terms of judge creating a term, it is much safer ground, if you like, conservative with a small c, as I've explained it, or orthodox, for the line that Fancourt J has taken to say, yes, it's possible to have a term implied, but you're going to have to do it as a matter of fact. That is much, much safer, because it is still, therefore, the contract created by the parties, not as a matter of social or other policy imposed on the parties by the common law, by the judge doing it. That is dangerous territory. You can do it in very isolated instances, so the fiduciary obligations as a matter of policy, the law says it must be this. Employer-employee, the law says it must be this. But it's very aggressive, if you think about it, for the common law. That's my basic point. It is much safer technique to use the implied by fact. And it's not a great hurdle or difficulty to the parties. In fact, it's probably easier to use that mechanism. But, you know, your point about the putting something in that's not been articulated by the parties, you know, that there's been enough discussion about good faith now since Yam Seng for practitioners who are crafting these agreements. This is £10 million, for Christ's sake. They would have had some expensive lawyers on this. They've had enough chance, as it were, to think, OK, this is a wake-up call, chaps. We need to make it very clear by the express terms where there is to be some aspect of good faith, and equally where there is not. So Fancourt makes the quite powerful point, I think, to say that the lawyers here had thought about good faith because they had put certain terms of that nature into the bargain. And the areas where they have not done so, we must assume that that's intentional.
Yes, and this is where the implication, in fact, or that's where the argument to say that when it is a very detailed agreement is, I agree, difficult to overcome in relation to the implication in law. Yeah. So I do see that, but it's a tiny bit...
Or implication by fact is the point I'm trying... It's shutting the door on that argument, because the court will say the parties have thought about this and decided no. And freedom of contract, big deal for English law. We must respect that decision.
And Midesex, the Court of Appeal clearly said that, once it is in the contract, you can't imply another one because for the same reason. But it's a little bit lazy. It is a little bit of a lazy argument. So what it is, you asked, what is commercially unacceptable. So here we go into the realm of good faith does not only demand of one party to exclude bad faith or not do anything that is unacceptable, not, refrain an excluder of bad faith, as it is called, as it is referred to in the States, but it is the cooperation. It is the doing something that is going to be necessary for the purpose for which the contract. So that doesn't negate. So again, Fancourt could have gone into a lot more details about Al Nehayan, Justice Legat's last decision on the bench, where Legat did try to articulate what it would mean precisely. And because looking at cases on the fear that you have articulated, Maggie, by the judges as to, what it means exactly, there is a fear that it would be contrary to some of the traditional position of the court to consider the parties at arm's length, that it would mean giving up of a financial advantage and other.
Yes. So remind me, but in Sheikh Tanoon, Legat LJ was saying it's not any long-term contract, but one that requires collaboration.
Yes.
I think that's the word that you used. Yes. And he says that you must operate in a way that respects the spirit and objectives of the
contract. So effectively, what Legat does in Al Nehayan is to say that good faith is not necessarily owed to an individual parties, but what the parties have to respect is the purpose of the contract. So that doesn't mean they cannot act for their own self-interest. That will never go away. And I think that's where the fear comes from the court, that suddenly it means a party cannot act for their own commercial self-interest. And so what Legat tried to, or what Legat articulated in Al Nehayan is the good faith is owed to the project, to the purpose of the contract. So what unites the parties? And so as long as a party acts in a manner to cooperate and to help the other party get to the purpose of the contract, then that doesn't necessarily mean they can't act for their own self-interest as long as they have a good commercial reason. So that is that part that I completely agree with you has not yet been completely articulated by the court, but because the court constantly go back into, oh, well, we don't have the tools, so therefore we can't articulate. And
couldn't you say, though, Severine, that this very low-level obligation, if you like, not to sabotage the agreement, the contract, it is implicit in all contracts, but it's such a low-level thing as to go without saying. But it's articulated or has a remedy, which is the more practical way of looking at this, through some other specific breach.
I think that's one of the things that I have been arguing with good faith. Good faith doesn't need to be this frightening thing. I think so if you look at how good faith has been received by the various court post Legat and Janssen, we've had, on the one hand, those who have embraced it, and on the other side, those who have, looked at it in fear. And the theme that is running through those who have embraced it is, it is nothing to be feared. It doesn't mean it's going to completely ruin the ideas upon which contract law are created. So indeed, it is based on the purpose of the contract and indeed not sabotaging, so allowing the other party to get the fruit of the contract, not in a underhand manner. So I think what is being, for me, the underlying idea is opportunistic behavior is not possible. And that is a theme that already exists in English contract law.
But what does that actually mean, though? What does opportunist behavior mean?
So if you have, the contract aims must be respected by both parties. And if one party, as there seem to be here, the way Tim has explained the facts, potentially here did the Sheffield United try to make a quick buck by effectively trying to get something at a really, really low price. And that has not been explored here, and perhaps could have been done, explored in more details. So that is the contract set out a certain a purpose, a certain expectations. And if one party tries to get away from these expectations, that's when that is not going to be allowed for good faith.
And I do think there is a difference there. Actually, before I think that, do you know who always acts in good faith?
Sorry?
I know where he's going now, Severine.
Well, our sponsor, Newcastle Law School.
Sponsor always acts in good faith. Well done, then. We are very grateful as ever.
Thank you. Would you like to be at the forefront of law and technology? Well, Newcastle Law School is now offering a brand new LLM in emerging technologies and the law. To find out how law, economics, politics and society intersect in a digital world, visit ncl.ac.uk to find out more. Thank you, Newcastle Law School, for sponsoring Unpacking Contract Law. I'd like to come back to that point. I don't think every contract is built around the purpose of the contract. And doesn't have to be, and shouldn't be. I'm going to give a really bad example, and you're probably going to be able to unpack this, but it's the best I can come up with on the fly, is a delivery company that notices that I'm not in, they have the obligation to deliver to my premises. Now,
This is beginning to sound like a problem that Tim has
no,
had.
I haven't actually. No, I'm thinking of a big commercial one, not me personally. This is, big commercial yard. They've been told, deliver it to the yard, that's it. They don't see anyone there. They drop the pallet in the middle of the road or in the middle of the access area, which means no other lorries could get in. Generally, contract law would be fine with that. The whole point was to drop off the pallet at the end destination. There's no obligation to put it somewhere, protected or do anything else. If the spirit of the contract was different, if we said this was a joint venture, you'd have an obligation to call or let them know that it's there now, or protect it, or put a covering over it.
I don't think English common law would have much difficulty with a term implied as a matter of fact, either on obviousness or on workability. The delivery has to be somewhere where the item is safe, won't cause a hazard to traffic, as a minimum, as an implied term. I don't think you need
that's reasonable,
good
or
faith
not. That's
for this.
reasonable, not necessary.
No. It's not reasonable. It's workability or obviousness. Either of those, I think, would probably work in the example that you give. If you're delivering, it must be into the yard, not on the roadway, for example, and it needs to not be causing a hazard to traffic. As a matter of obviousness, or in terms of workability. More obviously, if I had to put my name to a point, I would say as obvious.
So the Moorcock kind of argument of, yes.
Yeah. So, English law has been working on this for 800 years. And here's the problem. English law tends to be quite piecemeal, if you understand what I mean by that, in its responses to bad faith. I think English law is pretty geared up to police bad faith.
It's Lord Bingham all over, isn't it?
What does he call it? Functional equivalence. That's his phrase. Functional equivalence. It's just a different way of tackling a similar sort of problem. For example, the various forms of estoppel. Okay, it's not contract law, another branch of law, been developing for 500 years. It's naturally geared at what we would now call unconscionability, and perhaps a French lawyer would use the phrase good faith. Fine, happy with that. Different way of tackling the same sorts of problems. So all I'm trying to say is we have a mechanism for dealing with bad faith. We're just not that clued up to deal with it explicitly as imposing an obligation of good faith for the reasons that I've said, the lack of transparency as to what this means and the potential intrusion into the bargain that the parties have made, particularly if you're arguing that this is so as a matter of implication of law rather than for workability or obviousness as a matter of fact that the parties must have assumed to have taken on board these points.
Might we be able to argue the other way, though? Might we be able to say that actually there is a term implied in law in joint venture cases, but in this case, the fact that the contract was so sophisticated, so obvious, and even maybe the fact that both parties were not exactly acting in the very best faith, let's put it that way, actually just excluded good faith. So in other words, we have we do have the general implied term here, but actually it was excluded by the facts of the case. In other words, what I'm trying to push us towards is actually looking at the facts of the case, whether we think this could ever be a good faith case.
Well, I suppose Fancourt J is hinting at this when he said at one point, there has been a tendency in recent cases, so that's the criticism of Bates, to simply ask the question, is this a relational contract or not? And he's saying that is by its nature not a very helpful way of tackling these things because it's apt to mislead. What do you mean by a relational contract? And there's a very wide spectrum, I suppose, of contracts that would fall into that very loose umbrella term. And there comes the problem. There may be some contracts where the relationship is very close. You might even say, as was argued in this case, a quasi-partnership dressed up using the trappings of limited companies. In other words, they were very close and personally very close, and it was dependent on individuals, not legal entities. There was two human beings that had to work closely together. I can see that in that very narrow area of types of contracts, yes, it's going to be far easier than perhaps other types of commercial joint ventures for English law to say, as a matter of fact, we can see that some articulated form of good faith is an implied term if the parties haven't actually explicitly said it as an express term. But there are other types of contracts where parties do have to work together. They're probably not individuals as the ones that I'm thinking of at the other end of the spectrum. They're limited liability companies. It's not a quasi partnership, as was rejected in this case. Although you might say they're in a joint venture, that joint venture only goes so far. That was the point I was trying to make about 20 minutes or so, that in essence, this is a contest or power struggle for control over a football club. And so this joint venture labelling only goes so far, you know?
Yes, the court.
That is my difficulty.
Yes, I mean, it is clear because, in Bates, the judge whose name escapes me tried to define relational contract. So it is true that until we can define relational contract, it is true that, you know, there is a problem. But relational contract and good faith. So I want to go back to some of the things that you've mentioned earlier, that English law doesn't have a problem with good faith as I go back to my expression, the excluder of bad faith. I agree with that. And this is a trait of the way English law developed piecemeal, and in the same, we can see it in the same manner. There is no obligation to disclose, but we have so many exceptions to the non-disclosure that is the way English law has developed. There is no positive obligation to do something, but it's always as what not to do. So and this is because English law, it's so that the law develops in line with the rationale of certainty and freedom of contract and all that. But so here, the argument is that can we go beyond this limited view of good faith as what not to do? And this is the difficulty of what, and you go back to what you were saying earlier, Maggie, what exactly would it mean? So cooperation. So I've tried to articulate that in relation to Al-Nihayat, that as long as the parties do not continue to help each other cooperate and achieve what the contract aim has done, and do not do anything just for their sole interest, which is not in line with commercial expectation and the contract purpose as defined. So that doesn't necessarily change the whole ethos and the whole basis upon which contract law has been, as you said, developed in the last, so many hundred years. But it then allows to articulate what a positive obligation of good faith, rather than simply what not to do. The link would help to define what it would mean for the parties. And this is where the relational aspect comes in. And I go back to what Tim said about the non-articulated. I mean, Legat and Fancourt quoted him on saying that not everything can be included into the contract. And this is what is not said into the contract, but can nevertheless be seen, although not expressly articulated. So,
okay, I agree with that. If it meets the test of either it's obvious or it is necessary to make the thing as articulated workable. If it can meet either of those, then fine. I don't have any problem with it at all. That's exactly what I think Justice Fancourt is saying. But you've got to meet one or other of those hurdles.
So do you agree with Yam Seng then?
No. Part of Yam Seng, where Lord Justice, or Lord Legate as he is now, is saying, as a matter of fact, one can imply a degree of specificity other than using the phrase good faith. If it meets the obviousness test or the workability, that bit of the judgment, yes, I agree with. But then when he says, in the alternative, I would also have found a term implied as a matter of law, that's where I have a problem. That's where Justice Fancourt has a problem. That's where the Court of Appeal in Mid-Essex has a problem. So it's not just me. There are some of us out here have a problem with that further step. And you might say to me, or a listener might say, what the hell does it matter? If it's either implied as a matter of fact or implied as a matter of law, who cares? And the answer to that is, I think, implied by fact is doing far less violence to the terms as they have been articulated. Implying a term as a matter of law is, to a lawyer, much more aggressively altering the bargain. And that's why there is a tension, if you like, or a sort of inbuilt struggle, which an old fuddy-duddy English lawyer like me has a, that is a bridge too far, as it were.
Damn, I thought actually we agreed for a split second.
For a split second.
You might have to do some serious editing.
We're agreed on the possibility. We're agreed on the possibility of a term being implied. I agree that far.
So
where we don't agree is the nature of it. I am saying it has to be very specific. That labelling good faith, as you use the word lazy, Severine, I'd use it back to you, is lazy in terms of English law. What do you mean by that? You must articulate that with much degree of precision. And yet I go back.
You see this argument that English law doesn't, it needs to be precise. Everything, the UCTA, about, on whether a term is unfair or not, the criteria are very vague. So I don't know why.
But that's different.
Oh, why?
Unfair Contract Terms Act is statute.
I know, but still.
Yes, but that's statute. That's supreme, if you like, the division of the powers and all of that jazz. The law, in terms of Parliament, may say, judges, you have the power to decide whether an express term that the parties have agreed is unreasonable and unfair or not. That's Parliament giving judges the power. That is fine. I have no difficulty with that at all, because that's the way our system functions. But it is an entirely different argument to say the judge may decide what is reasonable, commercial, acceptable behaviour, although the parties have not themselves articulated that. By the route of implied by as a matter of law, that is an entirely different game.
Oh,
that's opened up a can of worms there.
So I think all that point of difficulty, the last 50 odd minutes or so, the only real point of difference, I think, between Severine and I is that you would be much happier, if I can express it that way, with English law recognising the possibility of a term which we might label good faith, but I think you'd agree with me, it has to be articulated with more precision. But your stance, I think, is it can be and should be in some situations implied as a matter of law. So you're much more in keeping with Lord Legate's obiter comment in Yam Seng and the way in which the judge approached it in Bates and the Post Office. And I am at the other side of the approach, as it were. I am much more with Fancourt J in the Sheffield United case in saying, OK, it's possible, but as a matter of fact.
And you've managed to articulate it in much fewer paragraphs.
I know.
Well, I don't know, because we've been arguing about this for 50 odd minutes. This could well be 500 paragraphs.
Shall we stop here? We have got a truce. we agree on something.
We're close enough. I was just going to throw another one in, but then looking at the time, we might not be able to get to that. Okay, we'll throw it in anyway, just a quick one. To what extent do you think, if we look at Bates, for example, one party was clearly quite reliant on the other one and clearly quite reliant on the other one not to subvert the contract. To what extent does that play a role when we then look at this case and think, you know what, they both knew who they were who they were contracting with and how they were getting into this. Actually, they weren't that reliant on each other. They were all pushing for their own agenda. They all had their own ideas of where things were going. To what extent does that play a role?
I can see the Bates case as much closer in terms of a very close, mutually dependent relationship, if I can express it thus, because you've got sub-postmasters and mistresses who in any other walk of life the English law would label as consumers. It just happens to be that they were doing this for their only form of income in many instances, and they were wholly dependent on the veracity, genuineness, transparency, honesty of the post office and their IT system. So I have no difficulty at all in that setting saying English law would imply, as a matter of fact, between those parties, it's very close to employer-employee. And in a sense, in terms of legal smart drafting, in any other setting, that would have been an employer-employee relationship. It's just that it was dressed up as independent contractors for tax reasons. But in any other walk of life, English law would have said they were wholly reliant on the post office and they were as near as damn it employees. So that is much closer to the implied by law. I will accept setting. It is only by clever drafting, clever bit of lawyers, if you like, acting for the post office, that these documents were dressed up as not being employer-employee. Now, English law is on to them, if you like, and so I would say would have no difficulty in policing by an implied term, as a matter of fact, that there was on the facts a high degree of mutual dependency and very one-sided arrangement. The sub-postmasters and mistresses were wholly dependent on the IT system, which the post office were responsible for, were wholly dependent on the honesty and truthfulness of everything that the post office said to them about flaws or otherwise in that system. And the post office repeatedly lied to them. And that is right in the area of bad faith in terms of what English law would recognise. So I have no difficulty at all with what happened in Bates. It is simply, if you like, a lawyer-like argument here as to the way in which that is being explained. So implied as a matter of law, I still have. I'm sorry, Severine. I truthfully have listened to your argument over the last 50 minutes, and you are in good company with Lord Leggatt. And who am I to criticise either you or Lord Leggatt? But I'm afraid I am.
Everything that you've said, Maggie, I agree with, and this therefore goes so. In a way, by throwing what you've thrown, Tim, you've just, highlighted the difficulty of and the need for further work to be done on what we mean by a relational contract and what we mean by. So here we have two extremes. So I completely agree with you, Maggie, and Tim, I'm sure you would agree of the notion of dependency, because this is something we're working on. There is a spectrum, once again, of relational contract. And so it is absolutely true that in relation to relational contract, there is a lot more work to be done to decide what are the factors that dictate a contract to be regarded as relational. But I think some of the issues that you have highlighted, the notion of relational contract in Bates was argued to indeed show that dependency, that there was a weaker party.
Yeah. Yeah.
So
yeah, I would say to you, if you're doing research on this, Bates is a paradigm case of what I would call a quasi employer-employee.
yeah,
So that is your sort of sort of classic
yeah.
area
Why?
of.
But the way I argue good faith is not necessarily so. Clearly, the post office masters and mistresses were the weaker parties, for want of a better word, for want of a generic word, and therefore needed protection, and therefore the good faith obligation of cooperation, which was implied in, that's the cooperation. It's not just an excluder of good faith. They should have done a lot more because of what you've just said, Maggie, that, they were in a weaker position. They were completely dependent and everything was dictated by the post office. But in relation to a more traditional commercial relationship, as we can see in the case we're discussing, where indeed, both parties were sophisticated businessmen. So the good faith here comes on a slightly different basis, but it's a different iteration of the need for good faith here. Just because they are at a much more equal relationship does not mean that one party can you can still be taken advantage of, even though.
Okay, so would you say therefore that the content of the good faith obligation would have quite a different description or definition?
Yes, because it is
because of that quite different relationship. Yeah, I have no difficulty with that. It's just simply the basis upon which it's being implied. You're coming at it as a matter of law, and I'm coming at it as a matter of fact. So I think we agree that because the settings are quite different, the content of what we're talking about would necessarily be different. And so maybe you're agreeing with me now,
Maybe you are agreeing with me.
That the label good faith is not terribly helpful. It's just a very simple labeling. You have to dig much further as to what you mean, and what you mean may vary greatly from context to context.
But as you see, I guess that's where my background as a civil lawyer doesn't, I don't see the problem, because in France, where, I was partly educated, good faith is not defined. So the reluctance, that is not a problem. Good faith is not defined in the American Uniform Code. It's not defined in. So now, the fact that good faith is not defined is not a problem, because But
can you see it's a problem to English law?
I don't know, for the
traditional
for the same reason that it then allows the flexibility for the judges to apply it depending on the context, depending on the need, depending on the relationship. So, no, I don't really...
But because we put quite a lot of weight on certainty and predictability...
Yes, so again, I go back to...
It's more of a problem for us than it is for the French.
Or it is because of the way English law has developed. And I think that the point that you made when we were discussing the statute. So I guess maybe that explained that in a statute, when a statute something is vague, that's not a problem. But it seems to be a problem in relation to when there is no statute, and therefore when the judges have to apply their discretion. But for me, again, being, looking at it from a pure civil law viewpoint, and the comparative contract law modules that we used to teach together, I always told my students, so on the one hand, we see civil law as the judges do not make the law because we don't have the notion of precedent, and in the in common law jurisdictions such as the UK, judges make the law. And yet, in the light of what you've just said, Maggie, there is a reluctance for the judges to agree that they make the law. But anyway, I'm going on a slightly different directions here.
Well, on this particular point, yes, there is reluctance because of the vagueness of the concept and the vagueness as to the types of contracts where it is to be implied. It's those two areas of uncertainty and vagueness which are creating a problem for us, I think.
And yet, if it's done within a statute...
that's fine.
Yeah,
that's
you see,
fine,
that doesn't make
Parliament.
sense.
Parliament
I
may
know.
do more or less anything in our
I
constitution.
know, and yet the true value of statutes is their interpretation. They are interpreted by the court. So why is there a fear of going?
Because interpretation is not creation.
Oh, is it not? Oh, well, maybe we can have
No.
another. Oh, okay.
No.
Well, that sounds like another whole other podcast coming up
I
here
know.
on interpretation construction. Oh, my goodness me.
So we're agreeing to disagree, I think, on that very small
We
point.
probably
I think
have
we've got that.
Yeah. We probably
Yeah,
have more in common to when we...
That's good. Yes.
Well, that was better than my summary. So I was probably going to summarise this as, we can agree that possibly somewhere there might be room for an implied duty of good faith in law, but one thing's for sure, this ain't it.
No.
Okay, even that one failed. Right, on that note, I think we're going to wrap it up there because this might go on. But we will be back, and I don't think this is the last time we're going to be debating good faith. It was good fun. The question is this podcast still a joint venture?
Of course it is. Of course
it is. Excellent.
We are constantly exercising good.
Yeah.
I would
we
say
are.
so too. On that bombshell, thank you very much for listening. Do contact us at unpacking.contract.law@gmail.com, and well, enjoy the rest of your day, hopefully in good faith. Thank you. Bye.
Bye.